As President of the Political and Legal Educators Association of Western Australia, I would like to warmly welcome all our attendees to the State Library for our very first Year 11 exam revision seminar. PLEAWA is sure you'll enjoy and benefit from the wonderful presentations today. We are all working towards the same goal to encourage you, the students, to achieve to your fullest potential. A huge thank you to all our presenters, as well as our wonderful PLEAWA committee volunteers who have put together this evening session for all of our students. Firstly, I'd like to begin by acknowledging the traditional custodians and owners of the land we are gathering on today, the Whadjuk Noongar people, and pay our deepest respect to the elders, past, present, and future. So, to begin tonight's presentation, I'd like to welcome Mr. Alex Rosevear, Head of House at Shenton College, to present about the principles of a liberal democracy, as well as the separation of powers in Australia's political and legal system. Thank you, Alex.
Thank you, Lisa. First up, I'd like to begin by talking about the three branches of government, these being the legislative, executive and judicial branches. By this stage in the course, you should certainly know their functions. For the legislature, it's to make, amend and repeal law, and for our purposes, we call that the parliament. The executive, which we generically call the government, carries out that law, and the courts, the judicial branch, interpret the law and apply sanctions. The concept of the separation of powers is crucial to a liberal democracy. A liberal democracy seeks to avoid tyranny, and it is argued that a liberal democracy will do what it can to separate powers so that no one person or group of people can wield too much power across the state. It's ultimately argued best by Montesquieu in the early 18th century. But Montesquieu did more than propose that power be separated. He specifically argued that the three branches should check and balance each other, complementing their ability to use power. He also argued that the courts were by far the most independent. And in doing this, it was in a position to be able to ensure the protection of the people from the power of the state, that is, protection from the arbitrary use of power. Montesquieu in particular valued the Westminster system of responsible government, and in the early 18th century, the British system of government was perhaps one of the most liberal that you would find in Europe. He particularly liked the idea of a fused legislature and executive, but most importantly, two features: an independent judiciary to protect the people and a system of government governed by a constitution. Okay. So let's have a look at the legislature. At the Commonwealth level, the legislature is provided for in Chapter 1 of the Constitution, starting with Section 1. A Commonwealth Parliament shall be comprised of the Queen, the Senate and the House of Representatives. At this point, I will point out the Constitution always makes reference to the Queen, but of course that also means really the sovereign or the sovereign of Australia. So we have these three parts of the Commonwealth Parliament outlined in Section 1. In liberal democracies, the primary role of the legislature is to propose and debate law, whether they be new amendments or to repeal such laws. Legislatures should also check the power of the executive and the courts, and this is usually done through legislation. However, Australia is a Westminster system of government, and our parliament has additional functions, which you will look at further in Year 12. One being to form and scrutinise government, the executive branch, and this helps achieve the principle of responsible government. Two, that the parliament is a forum for debate of important issues. And three, that the parliament represents the will of the people. Most legislatures, but not all, are bicameral, that is, they have two houses, exceptions being New Zealand or Queensland state parliament. The lower house, particularly in Westminster systems of government, is the seat of government, while the upper house is usually seen as a house of review. In Australia, we have two distinct chambers, the House of Representatives, which is the seat of government. And in the United States, they also have a House of Representatives, but it is not a seat of government. This is a point of difference that you can look at in Year 12. We got our idea of the seat of government from the UK, which is not federal, it's a unitary system of government, but we still borrowed the idea from them. All three countries outlined just then have an upper house, a second house. For Australia and the United States, this is the Senate, and both see it as a house of review and a states house. A key difference in the legislature structure in the United States is that the Senate has a check on executive power, which we will look at in a moment. In the UK, their upper house is a significantly weakened House of Lords, which has a role in review, but ultimately cannot frustrate the plans of government, unlike the Senate in Australia. Finally, the third part of our legislature and our legislative process is that the King grants royal assent. This is similar in the United States in that the head of the executive branch, the President, also grants approval to legislation, and same in the UK with the King granting royal assent. So the provision for the legislature in Australia, the Commonwealth Parliament, the House of Representatives is formed in Chapter 1, Part 3. Chapter 1, Part 2 provides for the Senate, and the monarch is provided for in the legislative function under sections 1 and 2. The terms for the House of Reps is 3 years, for the Senate 6, but if you're a territory senator, it will be for 3 years. And the term of office for the monarch is for life. Currently, in the House of Representatives, we have 151 members, and it's prescribed in section 24 that it should be approximately twice the size of the Senate. The Senate has changed its size twice, originally from 6 to 8, and it is now at 12. 6 times 12 is 72, plus 4 from the territories means we have 76 senators. The monarch, their membership is limited only, obviously, to the one person. The electoral systems, majoritarian, allowing for responsible government to be much more effective in the House of Reps, and proportional in the Senate allows for a diversity of opinion to be sought when legislation is being made. Another key feature of a liberal democracy, that we have pluralism. That is a wide diversity of political discourse, mainly through political parties. The presiding officer for the House of Reps is the Speaker, and for the Senate, it is the President. The representative of the monarch, when Parliament is first called after an election, is the Governor-General, as outlined in section 2. Western Australia, and your Year 11 course does require an approach to look at the legislative branches, the political branches of Western Australia. Our Legislative Assembly and Council are provided for by the state constitution, and the King of Australia is also the King of Western Australia. The terms of office are different. They are both serving 4-year terms, and those elections are fixed. They are held in March every 4 years. So if you're in Year 11 now, you'll be eligible to vote at the next state election. There has been a change in the Legislative Council's membership, and in 2025, the proportional representation will remain the same, but it will be all 36 being elected by the entire state population who are eligible to vote, rather than the 6 regions with 6 representatives each. So that will be something new that you as politics and law students will be able to teach your parents about what the difference is, because they won't be familiar with it by that stage. Similar to the Commonwealth Parliament, we use full preferential for the lower house, and we use a single transferable vote preferential system for the council. The presiding officers are the same, except the monarch's representative is the governor. Here's a bit of colour for you. This is from the Parliamentary Education Office, showing the usual path of a bill, which I'm sure you are very familiar with, having studied civics in years 9 and 10, and earnestly studying politics in year 11. So as I said, one of the liberal democratic features of the separation of power is checking the use of power by the other branches. So I'll briefly go through how the legislature checks the power of the executive branch. First of all, the executive branch can be held in check when the Parliament seeks to amend or repeal or create new laws that the executive wants or might be abusing. There are occasions in which the Parliament will strip a minister, for example, of power. This occurred with Tony Abbott as health minister, I think in 2005, over the RU486 pharmaceutical abortion pill. And we have also seen the Parliament pass Medivac legislation, which limited the power of ministers to execute the immigration laws as they saw fit. That said, because the executive branch generally controls the lower house, this is not really a strong power of the legislature, because if the government doesn't like it and they have a majority in the lower house, it will not pass. Another function of the legislature checking the executive branch, which we'll look at in a lot more detail in Year 12, is through the scrutiny of committees, debates, and question time. And in some countries, particularly the United States, which many of you will be studying next year as another country to compare the 3 branches of government with, the legislative branch has a considerable say in the appointment of executive positions, such as cabinet secretaries and heads of major departments. The judicial branch. is checked by the legislature in a very important way. If the parliament so chooses, they can legislate over common law, or they can embrace common law. Native title is a good example of this, and you should look at that next year. Following the Mabo decision in 1992, creating the common law decision of native title, the Parliament in 1993 chose to embrace it and create the Native Title Act. An extension of such a common law now made statute was the Wick decision in 1996, which was in many ways altered and limited through the Native Title Amendment Act. So the Parliament can restrict the judicial powers of the judiciary by using statute to override or change common law decisions. I want to point out here a common mistake students make is that they assume that the Parliament can overturn judicial decisions. They cannot, and that has been demonstrated by the High Court. All the Parliament can do is change the law in futuro so that the courts are bound by more tighter, more restrictive statutes, but they cannot overturn a decision that has already been made that's left to the appellate structure of the judiciary. Another function of the legislature checking in the judiciary is clarifying statutes, an important feature and something that you'll probably study next year if you look at Workpack and Rosato. And they can also legislate the judicial power of the courts. The Constitution provides that there must be a High Court, but all other courts are created by the Parliament, and the powers of those courts are prescribed to them through legislation. And we have, since 1901, seen a number of federal courts created and dissolved and merged. A recent example being the Family Court has been merged with the Federal Court. Thereby, the legislature can, if it wishes, curb the power or expand the power of the courts. It just cannot do a great deal about the High Court. And finally, the one that's never really been used is Section 72 of the Constitution. The legislature can check the judiciary by seeking the removal of a federal judge. As I said, this has never occurred, but it's technically possible. When we look at the second branch of government, that is the executive. And at the Commonwealth level, the executive is provided for in Chapter 2. In particular, Section 61 vests the executive power in the Queen, currently the King of Australia, to be exercised by the Governor-General. The roles of the executive are considered to be to propose laws to the legislature. After all, it's the executive that has to carry out the law. If they see a need for change, they will make such proposals to the Parliament. Carry out the existing law through policy. So policies are backed up by legislation. And also Parliament does delegate significant powers to the executive branch for the day-to-day running of the country. In fact, a great deal of law in Australia is granted through delegate power known as regulations. The structure of Australia's executive is different from non-Westminster countries. We effectively have three sub-branches to the executive, and I'll go through those with you. First up, the constitutionally most important is that the Governor-General represents the King as the head of the executive, and they officially exercise the monarch's power. This is outlined in Section 61. Westminster Convention, however, requires that the Prime Minister, as the head of government, and an elected member of the Parliament is the person that the Governor-General takes advice from. So therefore, what we have is a one step removed. The Governor-General has significant power, but they can really only exercise it by a democratically elected leader of the House of Representatives, who we would refer to as the Prime Minister, and they are the head of government. For this reason, the Governor-General avoids using their executive powers on their own. It's the Prime Minister that actually uses those powers. And that takes us to what's called the political executive. The Governor-General will appoint a cabinet and ministry. This is outlined in Section 64 on the advice of the Prime Minister, and they run the various departments of state. In effect, the cabinet and ministry run the country. They must be members of Parliament. That's a constitutional requirement, meaning that in effect, our executive is generally considered to be an elected executive branch. These ministers are led by the Prime Minister and can be known as the real executive as well as the government. Because these ministers sit in Parliament, we have a fusing of the legislative and executive branch. That means we don't purely separate power. I'd like to urge students to note that simply because we don't perfectly pursue the separation of power does not make us a poor liberal democracy. If anything, Australia is an outstanding example of liberal democratic principles in action since 1901. For us, the concept of responsible government works very effectively for us and has made us one of the longest lasting democracies of modern times. When a minister or the entire government loses the confidence of the lower house, that is of the Parliament, then it is expected to resign. That's a topic you'll look at further in Year 12. The most important members of the political executive form cabinet. So this is your Prime Minister, your Deputy Prime Minister, Treasurer, Finance Minister, and all the big spending departments like defence, education and health. Cabinet coordinates national policy and they direct the public service. They are also considered to be the engine room of legislation. These are the people that develop about 98, 99% of legislation that Parliament will process and approve. So while the Governor-General has the technical power as the constitutional executive to dismiss the Prime Ministers and Ministers under Section 64, they only do so under emergency. And when you study the 1975 crisis, you can debate that to your heart's content as to whether the Governor-General was right or whether Gough Whitlam was right. So here you have a slide showing you the structure and roles of the constitutional, political and administrative executive. Leave that for now. That is something you will need to know next year. So this is something for you to hold on to your notes with. How does the executive check power? In relation to the legislature, it really only has one major strategy, and that is to call an election. The government, with its majority in the House of Reps, doesn't like to risk its majority, but if it is being blocked on key issues in the Senate, it can call an early election if it wishes. And in particular, if the government feels particularly brave, they can call a double dissolution election, which will dissolve both houses in their entirety. These are not common. The last was, however, in 2016, and they do tend to result in the legislature being held accountable by government reducing its majority or even losing office. So it's not a popular strategy for the executive branch. In checking the judiciary, the executive has a range of other strategies. First up, it drives the legislative agenda in Parliament. So it will propose to Parliament to change the law, amend or reinforce common law, or to change the judicial power of the courts. Another area of judicial review by the executive is through the Solicitor General. Whenever the Commonwealth loses a significant case or a case that it really feels matters to them in one of the inferior courts of the federal court, such as the Federal Circuit Court or the Federal Court, the Solicitor General coordinates the appeals to a superior court. Next year, if you're looking at the case of Sharma, that's a very good example in which a federal court made a decision about the power of a minister. The Solicitor General pursued the appeal through the High Court and won, overturning the federal court, thereby checking its power. And finally, the executive branch can confirm a request from the Parliament to remove a federal judge, but as I've said, this has never happened. So to the last branch, the judiciary. At the Commonwealth level, the judiciary is provided for, logically, in Chapter 3. Section 71 establishes the High Court and gives Parliament the power to create other courts. Appointments to the courts are made by the Governor-General in Council, so in real terms, it's the political executive that chooses who the court's judges will be. The roles of the judiciary can generally be considered to be to interpret and apply the law to resolve disputes and to administer justice, to create new law to resolve disputes where laws don't exist, we call this common law, and to also apply sanctions to those found guilty of breaking the law. And this is an important case that we would look at in year 12 when looking at Alexander versus the Minister for Home Affairs. The structure of the judiciary should be something you are familiar with. They operate under a hierarchy of original and appellate jurisdictions. In WA, you should know that it comes from the Magistrates Court, where summary offences are heard, through to District and then Supreme Court. The appellate jurisdiction chain is the same, except that the High Court, under Section 73, has the right to hear appeals from the courts of the states. In the Commonwealth, the order runs from Federal Circuit Court to Federal Court and High Court, and that is the same for the appellate jurisdiction. Another feature of the judicial structure is that every court, state and federal, has their own Chief Justice who oversee the operations of their own courts, and this serves as an accountability mechanism of the judiciary for the judiciary. Chief Justices can see that the magistrates or judges are actually doing their job as they should do and upholding high standards of judicial interpretation and activity. And here we have the appellate chain, which you should be familiar with. There is an error on this one. I've put Commonwealth under Federal Magistrates Court. That's a throwback to the 1990s. It's Federal Circuit Court. So apologies for that. It will need to be corrected. For those of you who are unaware of it, and it does come up, original jurisdiction is simply where a court hears a case for the first time. It should not be confused with a person going to the High Court to lodge an appeal against a government decision or a decision against the Parliament to make law on a matter. That would still be the court of first instance. It would not be a court of appeal. A court of appeal only hears a case on the grounds that the decision of the court may have been flawed for errors in law or fact. So original jurisdiction means the court that hears a dispute for the first time. Thereafter, it would be a court of appeal. Judicial independence is central to Montesquieu's theory of the separation of powers. To him, the executive branch was the most powerful, particularly living in France in the early 18th century, where the monarch was absolutely powerful. So if judicial independence is certainly achieved in Australia, we have an independent court structure guaranteed in Section 72 of the Constitution. The courts, no judge can easily be removed at a federal level without a very lengthy process to do so. The fact that the High Court has to exist and that its powers are prescribed in Section 73 and 75 and can be enhanced in Section 76, which we'll look at next year, means that the High Court enjoys a great deal of independence. And this independence has been very useful in protecting human rights and stopping the executive and legislative branches in particular from exceeding their powers. Hopefully next year, you'll look at a particularly important contemporary case of Alexander versus the Minister for Home Affairs, which highlights that the power to punish criminal activity is an independent power of the court and not something that Parliament can grant to the executive. It is something that Parliament grants to the judiciary. This reinforces judicial independence. So how does the judiciary check the power of the other two branches? Firstly, it can overturn legislation in the legislative branch that it finds to be unconstitutional. I've used an old example there, Australian Capital Television. You could use Williams 2 as another example, which is more recent, but not contemporary. They can determine the legitimacy of those who sit in Parliament to be in Parliament. Next year, you'll probably be looking at Section 44 and the Citizenship 7 case. And also the judiciary check the legislature by resolving disputes that occur during elections. When the judiciary check the power of the executive, they have two main ways of doing this. They can issue what's called a writ of mandamus, which temporarily prohibits a member of the executive from acting, and they can rule on the legitimacy of the executive to act. The aforementioned Alexander versus the Minister for Home Affairs is a good example of this. So hopefully you have come to understand throughout the course and through this brief presentation that the separation of powers is not only a key democratic principle to avoid the arbitrary use of power or it being concentrated in the hands of one or a small group of people, but it's also about checking power to ensure that no branch can overstep and assume greater power than it should. Australia is an excellent example of the separation of power, even though we do practice the principles of responsible government. I will now hand over to our next presentation to Daniel Tomlinson.
Okay, ready to go. So I'm going to be presenting on a non-common law system. Now, there are a variety out there that you may or may not have studied in class. So you might have looked at France. I've seen some look at Bulgaria. So regardless of what non-common law system you're doing, a lot of the points that I'm going to try and make through this presentation hopefully will be relevant to the inquisitorial systems that you're looking at. But I'm going to use the example of China. And let me tell you why. So first and foremost, I think that you can stretch a lot of the examples from looking at China's legal system to other parts of both the Year 11 and Year 12 courses. China can be considered to be a non-democratic political and legal system, which means that it falls into the Unit 1 dot point. It obviously has a legislature, executive, and judiciary. So if you look at its powers in Year 12, that satisfies a non-Westminster system. You can look at the way human rights are protected or not in another country for Year 12. So a lot of the examples coming out of China can be used in very flexible ways. And that means saving a lot of the memory, which you can use for other things. So to give myself a break so I can have a drink of water, can I ask the people that are listening to this presentation to tell me what they know about China already? I'll give you 2 minutes and I want you to pick one of these sentence starters and finish it off. Just type it in the chat. Why would you consider China a non-democratic system? What's the main reason? Can you give me a but? Why might China be considered somewhat democratic? Or if you can tell me what kind of political system China actually has, drop that in the chat. So pick one, type it out. Please someone do this or I'll cry. Nothing like guilt. If you're not sure, if you've never heard of China's political system, tell me something that you know about China, just so I don't. Oh, here we go. China are a non-democratic system as they don't have free and fair elections for any level of government above local elections, and even their local elections are a little bit dodge. China is undemocratic because its supreme leader is entirely unchallenged. Absolutely. China is considered by many to be a non-democratic system because it lacks free and fair elections. Love that. Authoritarian regime, which consists of a concentration of power in a leader which is not constitutionally responsible to the people. Absolutely. Arguably, you could say, yes, arguably you could say the Communist Party itself is not responsible to the people, yet exercises a ton of power. This is wonderful. Okay, you guys have a lot of knowledge on China. This is going to be great. All right, keep those coming in. I'm going to proceed because now I'm in a better place. So, in looking at a non-common law system, there will be essential terms, regardless of what system that you're looking at, that you need to know. They are listed at the top, in the top left there. Things like you need to know what the inquisitorial system is, you should know what codification means, the difference between common law system and civil law system. However, there will also be, I think, context-specific terms, which you may need to define specific to your country. For instance, China, they have something unique to socialist systems called a procuratorate. In France, they obviously have the role of the parquet, or here's my French, juge instructor, where you may need to be able to define what those terms mean within that specific context. Likewise, you will need to know the meanings of essential understandings. For instance, natural justice and its pillars or sub-principles, like evidence-based decisions, for instance, and be able to connect the specific aspects of a non-common law system to those essential understandings. Something to keep in mind, which I think is quite important, is when we talk about adversarial and inquisitorial systems, that we are not talking about a binary, we are often talking about a spectrum. For instance, even though Australia can be considered to be an adversarial system, we have over time incorporated some inquisitorial elements, or elements inspired by inquisitorial systems. So in our civil law system, for instance, case management, where judges and registrars can actively get involved in the pretrial process, that was inspired by the inquisitorial system because it improves efficiency. If you look at, for instance, China, China has introduced a burden of proof that is very, very similar to most adversarial nations. That is, in the criminal system, they have beyond reasonable doubt. And in the civil system, it is on the preponderance of evidence, both of which are taken from more adversarial systems. So it's important to keep in mind that sometimes these systems are inspired by each other and will make small changes based on the flaws that they see. So my first piece of advice to you is before you look at just the non-common law legal system, you need to also understand how that legal system interacts with the broader political system, especially when you look at things like judicial independence. Piece of advice, go find a diagram. That's a handy diagram provided by the textbook writer, who's right here in the room with us, guys. It's amazing. You can go find a diagram of a political system. And if you find it a little bit confusing, that's okay. You can actually explain in your own words what the diagram is trying to tell you. For instance, in this diagram, hopefully it becomes clear to you that the Communist Party plays a role in appointing all three arms of government. Because the Communist Party controls about 70% of seats in the National People's Congress, the Chinese national legislature, and the legislature appoints the executive and the judiciary, that is a problem when it comes to the separation of powers. By explaining these diagrams, you're actually engaging in something called the self-explanation effect. And a lot of cognitive research tells us that by explaining things in your own words and sorting through them by writing them down, you are actively taking them on board and processing them to a greater degree. Speaking of judicial independence, China doesn't have it. The Chinese Communist Party, because it dominates the legislature at each level of government, both the National People's Congress, which is the national legislature, but even the local people's congresses as well. And the legislature then appoints the executive and judicial organs and can amend the constitution. You could argue that all three arms of government are controlled by the legislature and in turn the Chinese Communist Party. We also see that the National People's Congress Standing Committee can issue authoritative interpretations of the law. A good example of this, which I don't have on the slide, so you might want to write this down, is in 2016, that Standing Committee interpreted Hong Kong's basic law, and they made it so that support for a one China policy, that is a united Hong Kong and China, was mandatory in order to sit in the Hong Kong legislature. So if you live in Hong Kong and you didn't want to be part of China anymore, you couldn't be elected into the parliament. And that was an authoritative interpretation of law, didn't have to go through the courts. That was the legislature declaring what the law meant and exercising what we would consider to be judicial power. Courts are also accountable to the legislature at their respective level of government. They are independent in theory, but not in practice. They can always be overruled. This may not be the case for the non-common law system that you're looking at. If there is a more strict separation of powers, or even just a greater separation of powers, like I imagine there would be in more democratic systems like France, then perhaps the inquisitorial system will be a lot more effective in providing natural justice. But as I'm going to argue, that will not be the case for China. To begin digesting the non-common law system in China, I want to look at the roles of different participants. In China, there's a few unique participants like people's assessors and people's procuratorate, but the others should be familiar to you: judges, police, defense, and witnesses. The way that I work through this in class is I literally ask my students to summarize the role of each of these bodies, highlight any similarities they see with the adversarial system, and then explain the key differences. That is, not only just outline what the key differences are, but where they come from or why they would be significant. You got some prompts there. So, in China, there's never just one judge. Very, very rarely is there. Instead, there is something called an adjudication panel. This consists of both professional judges and something called assessors. Assessors are just ordinary citizens. They are brought in to hear cases, and it is their career for a 3 to 5 year term. The panels don't always feature assessors, but there are enough of them that they sit on about above 70% of cases. The trials are led by the presiding judges, who are professional judges, but the assessors participate otherwise on equal footing. That is, they participate actively in the trial, they vote on guilt or not guilt, and they are able to question witnesses. The role of judges, as in any inquisitorial system, is a lot more active. They are able to interview witnesses. They are able to request the collection of additional evidence during a trial. They can facilitate like mediation in the pretrial process. They can modify coercive measures. That is, they can make warrants for arrest. They can also ask for pretrial detention. And they manage trial procedure and issue judgment. The key distinguishing features are that they are far more active in discovering the truth, and they drive trial procedure, unlike in the adversarial system, where often it is the parties, the defense and the prosecution in a criminal case that drive proceedings. Are people's assessors part of the Chinese Communist Party? No, they may be members of the Chinese Communist Party. However, it is important to remember who is appointing assessors. So it is the legislatures within China that are appointing people's assessors. And if they are controlled, the legislatures, by the Chinese Communist Party, then I doubt people's assessors with a negative reputation or an anti-communist stance are being appointed. So here's a unique one: people's procuratorate. This is very much like the prosecution in the adversarial system, but what's interesting is that they also have the duty to supervise judicial proceedings. They work alongside police, and they often manage investigations. They are the ones who collect a lot of the evidence and compile it in dossiers. Once enough evidence has been compiled, they then file a bill of prosecution and take it to the courts. There is a procuratorate at each level of government, both so there's a local People's Congress, and there's also a local People's Procuratorate, just like there's a National People's Congress and a Supreme People's Procuratorate. So at each level of government, one of these exists. Because they tend to control what evidence goes into the dossier, which the judges rely upon often in the trial, we can often consider them to be gatekeepers. They control what evidence is allowed into the trial, which is a bit of a problem when it comes to something like equal hearing of both parties. There are the various roles of the procuratorate. They're the ones to initiate litigation. They manage the investigation of offences, including those committed by public servants, and they supervise the exercise of judicial power. This is an interesting one. If you are the defense in China, you can appeal once. You can appeal to the next court up in the court hierarchy. If you are the procuratorate, you have an unlimited power of appeal. Because their role and duty is to supervise the execution or the function of the judiciary. This obviously creates problems for the equal hearing of parties. They can also formulate interpretations of relevant law specific to the procuratorate. So they can make declarations with regards to laws about investigating crimes, for instance. And I hope, I'm breezing over these pretty quickly, but I'm hoping you can see the sources of law at the top of the slides if you want to go and verify this. That picture there is on the right is just to show you just how many cases these guys deal with. And perhaps one of the reasons they're favoring a more efficient inquisitorial system over an adversarial system. So at the end of this, we can say that the procurator has a privileged position rather than in adversarial systems where arguably there is a more balanced defense versus prosecution. The procuratorate carries a lot of power. They are the ones that control what evidence is admitted into the trial after the investigation. They manage the investigation. They can order coercive measures. They can order someone to be arrested. They can order someone to be put in pretrial detention. They have an unlimited power of appeal. So once you put all of this together, you can say that they have a privileged position. An interview done as part of an academic study by Yu Mo, said that judicial decisions must be based on the dossier of evidence. The facts and evidence come from the dossier. That comes from a judge and reflects the extent to which the dossier, the investigation performed by the procurator is central to a trial. This quote here suggests that prior to 2015, the prosecution and conviction rates were actually tied to the bonuses, reputation and promotion of prosecutors and judges and police. So over time, those three groups have formed working relationships of mutual benefit, whereas the defense has historically been like oppressed in China. And that creates an imbalance. So surely that's not the end of the story. Well, it's not. There is something also called an adjudication committee. Once a trial has been completed, the judges don't always make an immediate decision. Sometimes, if the case is sensitive, if the case involves national security, if the case is complex because of evidence, the judges will forward the case to an adjudication committee. This is comprised of a court's president, senior judges, court's president, vice president, and senior judges, and they review the dossier, the evidence presented to them, and they also review transcripts from the trial. If they choose to make a different decision to that of the judges must follow the decision of the adjudication committee. The more concerning part about this is that the procurator gets to sit in on these committee meetings. So the prosecution gets to be in the room. They don't get to vote, but they get to hold a discussion with the judges, and they get to influence the final decision they make, whereas the defense is not present here. I'll come back to the questions in the chat momentarily, my apologies. So surely there must be a role for the defense, and there is. In the criminal procedure law of China, if you want someone to defend you, they can be a lawyer, they could be a person recommended by a public organization to which the suspect belongs. So if they belong to a university, a colleague can defend you. They can be a guardian, relative, or a friend. You have a right to a defense as guaranteed by the Constitution, but this raises a few questions. Given what we've already heard, how much role does the defense play in pretrial processes? How qualified are the defenders that are provided? And how much power do they have? Well, they have a number of key roles. They can provide legal assistance to suspects and submit requests to the procuratorate. So if they don't like the conditions of detention, for instance, they can make a request. They can file petitions in court regarding, we want the collection of this piece of evidence. They can question witnesses and present evidence in court with the permission of the court. and they can submit evidence in civil cases and cross-examine evidence presented in civil cases. What you'll notice about a number of these roles is that they have to go through another body. They're relying on another body cooperating. The procuratorate is the other party, and yet you have to seek their permission in order to get access to suspects and defendants in some cases. The courts are not necessarily going to be friendly to the defense, and yet you have to file petitions through the court in order to collect evidence, whereas the procuratorate just gets to do that as part of their role. Not only that, defenders don't actually get to be involved until after an investigation has an interrogation has already taken place. The defense are formally involved once a bill of prosecution has been submitted to a people's court, but not before. Not only this, defenders have to be very careful throughout the investigation. If they are found to have destroyed or forged evidence or coerced witnesses into changing their testimony in defiance of the facts, they will be found guilty of a crime, and they can go to prison for up to 2 years. We have an example of this. This is Li Zhuang, he's pictured here. He was a defense lawyer acting on behalf of a businessman who was alleged to be a ringleader of organized crime, Gonggang Mo. Li prepared a defense on the basis that Gonggang Mo had confessed under duress, that is torture. He was prosecuted under Article 306, the section I read earlier, because Gang Mo testified that Li advised him to withdraw his confession. He was sentenced to 18 months imprisonment. He was forced to produce a confession by the government. He produced his as an acrostic poem with the first words reading, if I can read this properly, forced to plead guilty to probation. He was eventually released and provided this information to the Chinese media. If you have the case study book, there is also an excellent case study on the oppression of human rights lawyer Wang Quanzhang. Witnesses. In theory, people's courts have the power to summon and question witnesses, and they do. However, in practice, this rarely occurs because the courts rely almost solely on witness statements, the written statements collected by the procuratorates. Attendance rates at criminal trials, for instance, lies between 2% and 8%. So even if the defense has a right to cross-examine witnesses or ask questions, they rarely can because the witnesses don't show. In terms of rules of evidence, there are very few. In inquisitorial systems, you will not find complicated or like codified rules of evidence. The only codified rules of evidence in China have to do with not permitting illegally obtained evidence into court, for instance, that obtained under torture. There is no hearsay rule, there are no opinion rules. Quite simply, it is whatever the judge and the procurator lets fly. Thank you. So based on this sort of overview of the different roles, we can come to a few general conclusions. Firstly, you often find inquisitorial systems used in countries with very high populations. And as a result, we can conclude that it is a more efficient system of justice. It features a high chance of convicting and punishing criminals. And it makes sense that China has adopted it. Procuratorates and prosecutions have proven willing to prosecute public officials and initiate litigation on behalf of the public. For instance, in suing Chinese government agencies for not looking after the environment. They've done that before. In theory, they have a lot of positive features to their law. They have a right to defense in the Constitution. They have a burden of proof that is equivalent to ours. But this is in theory. In practice, because the judiciary is not independent, because power is concentrated in the hands of those with a vested interest in the judicial outcome, that is conviction or prosecution in a criminal case, it doesn't matter what the standard of proof is. What matters is the power that the different parties have. There have been reforms. In fact, China's criminal procedure law and civil procedure law are updated every couple of years with new sections. So they've indicated a willingness to expand the rules of evidence, particularly with regards to illegal evidence being introduced. And the consistency of law is also important to the Chinese Communist Party. They want to seem like they have a coherent system of law. And as a result, they've allowed, for instance, the Supreme People's Courts to issue non-binding guiding cases. It's like optional precedent. So rather than these guiding cases being binding on lower courts, they're just guides that you can maybe refer to if you want. So in a sense, low-level cases, everyday justice, there may not be a great risk of injustice there. But when it comes to sensitive, major, complicated cases, the risk of miscarriage of justice goes up. And I would encourage you to pursue these conclusions in other inquisitorial systems as well. In France, because there is a more strict separation of powers, does that counter the power that is afforded to the prosecution, for instance? How often are there robust rules of evidence? How often are they updated? What burden of proof exists in your non-common law system? For instance, in France, it is definitely not beyond reasonable doubt, as far as I know, in criminal trials. How am I going on time? 5 minutes? I'm going to answer a couple of questions. Yeah, so a couple of questions in the chat. Feel free to chuck them in there if you have any more. Has the Chinese Communist Party ever used initiating litigation on the behalf of people's interests to suit their own interests? Absolutely. I would argue that even pursuing environmental cases in the courts, first of all, makes them look good in the eyes of the public. And since reducing carbon emissions is actually in the interest of the Chinese Communist Party, like over the next decade or so, I think we will see procuratorates initiating public interest cases on behalf of the people in pro-environmental cases. And I don't think we'll see the Chinese Communist Party interfering with that. Do these weaknesses in China's judicial system occur because of their authoritarian political system or because of their inquisitorial judicial system? I don't know if you can separate the two. That's my initial reaction. I think the inquisitorial judicial system creates risks. An inquisitorial judicial system does afford more power to the prosecution. If you combine that then with an authoritarian political system, that just takes that to the nth degree. But it's an interesting question. I think certainly the lack of judicial independence plays a greater role, but there are clear weaknesses in the inquisitorial judicial system, which are made clearer by looking at a non-democratic system like China. Great question. Any other questions that people have? Otherwise, I will move on. Okay. I'm going to move on to our next presenter then. Our next presenter is the author of the textbook. It comes from Frederick Irwin Anglican School, and it is Stephen King presenting on electoral systems in Australia. Thank you very much.
Hello, everyone. My name's Stephen King. I'm the author of the textbook, so I hope you enjoy it. Apologies if you don't. I know it's heavy going, but the course is heavy going too, so congratulations for choosing it. I often start these sorts of presentations by just giving credit to students, because by choosing a subject like this, you automatically place yourself in a category of, I won't say elite, but certainly special category of Australians, because we have, our future depends on an educated citizenry and people who have the vote, which is everyone in Australia who's a citizen over the age of 18, being able to make informed choices at election time. So congratulations, and appreciate you guys doing the course in the first place. So let's get on with this. Look, this is a really big topic. The syllabus says electoral systems in Western Australia and the Commonwealth. I'm only going to do the Commonwealth, really. The West Australian system is very similar to the Commonwealth system, so you can almost take it for granted. I will summarise at the end some differences, just in case you have focused on the West Australian system more than the federal one. I often choose the federal one as well because it's more relevant to Year 12, where we look at the accountability of the Parliament via elections. So you really have to understand the West Australian, rather the Australian electoral system, if you're going to do a good job of that. So, okay, so this is almost like politics and history, because we're going back to federation to see how the electoral systems have evolved over time. So you would know that Australia has experimented with 3 electoral systems: first past the post, preferential voting, and proportional voting. And I'm working on the understanding that, or the assumption that that you have a fairly clear idea of these systems, how they work, what they're based on, some of their strengths and weaknesses, or advantages and disadvantages, and why Australia has adopted quite since 1949 a very unique solution to the problem of the weaknesses of electoral systems. There is no such thing as the ideal electoral system, but we have tried to blend two systems together to achieve what might be described as, the best possible outcome. We're not the only country that does that. The textbook also looks at the New Zealand electoral system, and they've attempted to do something similar, but they only have one House of Parliament in which to try and do it. So let's get started. Okay, so how do I advance the slide?
Oh, it's just the arrow.
Arrows? Okay. Nothing happening. Apologies, folks, technical issue. Oops. Thank you. Okay, so I'm just going to take a leaf out of my colleague's book and ask you to respond in the chat there about what this slide is really asking. We have electoral systems in the middle here. Votes go in, something happens in the system, and the result is a distribution of seats in the legislature. Down below it says that this really matters, exclamation. But let's turn that into a question. Why does this matter? I'll give you a minute or so just to respond in the chat there. Why does it matter what electoral system we choose? And we've got someone there from SC23. It has a major influence on the composition of the Parliament. Well, that is absolutely true. That is a short, sweet, and thoroughly accurate response. So well done. Let's just move on then. So we're getting a few more. The manner in which the will of the people is determined is essentially the entirety of what is government. Yes, it's a way of choosing government. The good electoral system is able to properly translate the will of the people and place it into power. That's true. We would hope that it does that. Some do it better than others. These are moving quite quickly now, so I'll just do one more and then we'll move on. So the electoral system determines the makeup of the Parliament. It also determines how many citizens' interests are represented. That's exactly right. So look, all of those comments are correct, and thank you for your interaction here. It makes it so much better. So yeah, maybe you can read those comments yourself as well. Okay, so these just taking your responses here, the choice of electoral system is critically important. A good electoral system needs to do a number of different things, and that's what this slide is about. Okay, so essentially, if there was such a thing as an ideal electoral system, and let's be clear, there isn't, but if there were, it would do a good job on all of the following things. It would be free. That doesn't mean not costing anything. Elections cost, I'm not sure, $200 million or something to run a federal election. They are really expensive. It's not free like that. What we mean here is free from interference and intimidation. That electors, and that's the proper word we ought to use, not voters, electors are free to make their choice without being bullied or intimidated by government officials, the police, thugs, family members, anybody. Okay, they should make their own free choice about their vote. And of course, that should be an informed vote, as we mentioned before. They should also be regular. And that's important from an accountability perspective, because if the term of the Parliament is too long, then it no longer really adequately expresses the will of the people. People's values change, our society evolves, issues arise, and things that were once very important aren't very important in the future. If we have, like, I don't know, a 7-year electoral cycle, our Parliament really would not be able to keep up with those sorts of changes. And we do live in a changing world, and the pace of change is increasing too. So arguably, a not too infrequent cycle would be a good thing. So it has to have some regularity. Not too short. I would argue perhaps that the US is too short with its electoral cycle for the House of Representatives and the Senate, its Congress. They're just in constant campaigning mode. They're always electioneering, which means they really haven't got breathing space to, particularly in the House of Representatives, where all of them are elected every 2 years. They're just constantly got an eye on the next election. So It can mean that difficult decisions, hard lawmaking, can be put off because it can be unpopular, and the legislators are fearful of the electorate not forgiving them or forgetting. So 2 years is perhaps too short. Britain's is 5 years. Arguably, that's getting a little bit long. Australia's federally is 3. West Australia's is 4. 3 to 4 is probably ideal. Okay. Some jurisdictions have fixed terms. West Australia has a fixed 4-year cycle, so the Premier, the head of government, has no opportunity to use their power to manipulate the electoral cycle for political advantage. It's locked in law. That's not the case federally. We have a 3-year minimum cycle, which means that prime ministers can go to the election at a time of their choosing within the limits of the Constitution. So we've seen that done a few times in recent times, where Prime Minister Scott Morrison was in a little trouble politically, and the polls indicating a loss both in 2019 and in 2022, and in both instances he delayed the election as long as possible. In the red circle, there should be a wide franchise. This means that the number of people who are entitled to vote should be the widest as possible. This does a couple of things. It ensures that the democratic principle, that is the will of the majority, or the majority rule, is genuinely expressed if we have all the citizens voting. If only a few vote, then we are going to only sample not a broad section of the community. We'll only hear from those who bothered to vote. So the widest possible franchise is good. It is also very good in a Year 12 concept called mandates. So, for instance, governments seek authority. They seek a democratic stamp of approval to carry out policies. So, for instance, Mr. Albanese's government has legislated for climate and is intending to legislate for integrity in government. These are 2 signature bills. He took those, Mr. Albanese and the Labor Party took those 2 promises to the election. They won the election. And so now it's very hard for anyone like the opposition, or maybe balance of power senators, to stand in the way and say, we're not going to legislate this. The government can use a win, if it's a wide franchise, can claim that the people have endorsed these policies. It does give some persuasive weight if a government is trying to negotiate with a hostile Senate or a difficult opposition that may not want to pass their laws. And finally, electoral systems need to be fair. And that means that, that means different things to different people. Okay, so fairness in a democratic sense means that the majority of voters, their preferences should be expressed as a majority of seats in Parliament. And in our Westminster system, as a former presenter noted, that the lower house forms the government. So we want a government that expresses the will of the people, and we need an electoral system that does that, and we do. But it also has to be fair, ideally, to all other political parties that are contesting the election, and they represent a range of ideologies, perspectives, maybe different regions in the country, etc. And we need an electoral system that gives voice to that diversity. And arguably, this is one of the things which is really difficult to achieve in a single system. It's a kind of, you take one and give up the other sort of deal if you only have one electoral system. Okay, so just in summary, the ideal electoral system would do all those 4 things. No system does, unfortunately. Okay, so the rest of the presentation is mostly diagrams, so I hope you're a visual learner. I certainly am. So look, we're just going to go through history here, because the syllabus point is looking at the the different electoral systems that have been used in Australia and Western Australia since Federation. And so what's important here is some dates and some events. So, from history, people, events, and ideas are really important. So that's kind of what we're looking at here. So there's some signature events. The ideas are the electoral systems rather, and what they're trying to achieve by choosing them. And in the people, I guess, are some of the political parties which largely have been able to implement these different systems, sometimes seeking advantage, but oftentimes creating something that was, much bigger and better than themselves. Okay, so starting in 1901, first thing to note is that the Commonwealth Parliament was created by the Constitution, came into being, but it obviously was composed of MPs and senators, MHRs in the lower house and senators in the upper house. The first Parliament, it had to be elected, but there was no federal electoral law because there had been no federal Parliament to make it. So interestingly and uniquely, never to be repeated, the very first election for the Commonwealth used the different state electoral systems in each state to choose the two houses. That is the one and only time that will ever happen, because one of the first acts of the new federal Parliament after it was elected was to create the Electoral Act 1902. The date tells you everything you need to know about the priority of getting an electoral system installed. So the second election of the Commonwealth Parliament used a national electoral system rather than 6 state ones. Interestingly, at the time of the very first election, South Australia was the only jurisdiction in Australia that gave women the vote. It also gave Indigenous people the vote and Indigenous women. So it was the only state in which women and Indigenous people voted for the Parliament. That ceased to be, for Indigenous voters at least, that was the one and only time until 1962 that First Nations people were able to vote. Right, so anyway, now, and by 1902, we've got the Electoral Act passed. And the diagram sums up pretty much what was happening. So we'll start on the left. Initially, there was no compulsory voting in Australia. We had voluntary voting, much like every other liberal democracy, particularly Anglo ones. So I'm talking here like Britain, New Zealand, the United States, those deriving from the Anglosphere and drawing their political and legal systems and inspiration from Great Britain. So the voluntary voting was a feature of Australia's electoral system for the first near on 24 years. And the two houses were elected using the same electoral system, which was also pretty much adopted from the UK. This is the first past the post. So apologies for the abbreviations there, but FPP is first past the post. So you can see it's being used to elect both chambers of the federal parliament. If we go across further following the red arrows, and the green arrows, we can see the consequences. So the outcome of this choice is that, and I won't get too far into the detail here because I'm assuming that you know some of these things, but first past the post is one virtue is simplicity. It's easy to count. It's easy for voters to understand. You get a quick result and electors can quickly figure out who won. Who gets the most votes wins. It's as simple as that. You can't get a simpler system. You don't need to be literate to use this. Some countries use pictures and electors use thumbprints to vote. So it's quite a suitable system in countries that are maybe fledgling democracies, new democracies, or where rates of literacy are very low. Okay, so anyway, it was adopted in Australia pretty much because that was British practice. First past the post was used to elect both houses. It's a simple majority. You only need a majority of votes to win. And now the problem with this is that if you have a three-way contest or a four-corner contest between 3, 4 or more candidates, then it's quite possible for votes to go in different directions for parties that are similar, to split the vote between them and let a dissimilar third party come through the middle and win. You only really need to win the most number of votes. So you can end up, if you flip this around, let's say 40% of the electorate choose a candidate and 30% of the electorate choose another candidate and 30% a third candidate. Well, the 40%er is going to win. But if we can see by the simple maths that 60% of voters, the two 30% together, don't want that candidate. So it's a less than ideal system in terms of majority rule. And it has other flaws as well, which I won't go too much into. But just following on there to the right on the slide, the consequences, the electoral consequence, the representational consequences of this system is that it's severely unfair to minor parties. So we will end up with a two-party system, and that has been a feature of every electoral, every legislature in the world, including our own, which uses these systems, which are based on electorates where you only have a single representative. It's quite simple to understand why. If you have a single seat, a single representative per seat, then you win 100% of that seat, or you win 0%. It's totally binary. You win everything or you win nothing. So if you win 40% of the vote, as we discussed, you win 100% of the seat. That's called a winner's bonus, and it distorts in extremis the majority win. They win a lot more seats in Parliament than they deserve through their support in the community. And the consequence is that all of the diverse views that the voters express in their votes are eliminated by the electoral system, and you end up with a big winner and a big loser, who in the lower house we call the government and the opposition. Not so bad in the lower house, because we're trying to form governments in the lower house, and if you have a big winner, you end up with a stable government. So that is an advantage. So if you're looking under the smiley face there, you can see stable government. The winner's bonus does amplify majority rule, gives you stable government. The price is lack of representation. In the upper house, though, the upper house is a house of review. And if you're going to use this system to elect the upper house, then you're going to end up with a system which is rubber stamp if a government controls it, or a hostile Senate, which is going to just block everything. So the Senate is really hamstrung by this system. It's an adequate electoral system for the lower house. It is unsuited to the upper house. Okay, so let's just move on now and see where we went next. Okay, so you can see if there's an oval or a circle that's coloured yellow, that indicates where the changes were. So in 1924, compulsory voting was introduced into Australia. Okay, so we retained the first past the post system, so the electoral systems didn't change, but this time compulsory voting was a reform. It's quite a unique reform. Not many countries in the world do this. Malta, I think, does it. Belgium, I think, does it. But we're certainly in a fairly exclusive club of democracies. Not many do it. The upside here is that it makes the system much more representative. Governments have much stronger mandates, and it turns voting into a civic duty. It tends to make us all feel as if we should be part of something bigger than ourselves. And I guess the democracy sausages that we get at our become a bit of a party atmosphere sometimes around electoral booths is part of that. The downside here, the negative aspect of compulsory voting, is that we are forcing uninterested electors to vote. Oftentimes they're going to vote informally or donkey votes, and those informal votes won't have an impact on the election, but donkey votes can in tight contests. And some people argue that making voting an obligation rather than a right is an infringement of our rights. There's no right or wrong argument here. You just decide for yourself. But it certainly was a reform that had consequences for Australia's electoral systems. Okay, so another big change, 1918. Both houses switched to preferential voting. Preferential voting is a cousin of first past the post. It uses the same single member electorates, so it has all the same problems. It does amplify the majority. You get a winner's bonus. It's not quite as big a winner's bonus though, because you can't win with a simple majority. You have to compile an absolute majority, which means that the election sometimes, and increasingly in more modern times, is decided on the preferences of voters, because many candidates no longer receive 50% plus one of the first preferences and rely on second and third preferences to get elected. So this is good because it actually compensates for some of that unfairness. Minor parties might not win seats, and they tend not to, but at least they can negotiate with major parties for preference deals. So before the election happens, minor parties might be able to influence the policies of the two big parties that are going to win in order to get their preferences. So there is some compensation there for minor parties, even though they may not actually get any more seats. So you can see the consequences on the right of the slide there. We're still going to end up with two-party houses, the lower house dominated by two parties, and the same with the upper house. It has all the same problems that we had before. The Senate is just going to be an ineffective house of review because it's going to be rubber stamping the government if the government controls it, and it's just going to be blocking everything the government wants to do if it's controlled by the opposition. Okay, so let's move on and see what happened in 1949. So again, looking at the coloured in circles there, the coloured in yellowish coloured circles, this is the point at which Australia departs and becomes a real electoral innovative nation. We're very, very, I've got to say, and a bit of a patriot, I suppose, but in terms of the Anglo democracies, and we're not talking about Europe here, Europe has a different history. Germany, France, those countries have had proportional representation for years. In Germany's case, there's a really good reason for that, because majority rule didn't work out very well for them in 1933. So they have made it impossible really to elect a sort of, a populist figure like Hitler or, I don't know, a populist, terrible leader can get elected, and that's a consequence of the winner's bonus and lack of representation. So those countries have really become quite innovative because of their history. We don't have that history. But we have had some enlightened political leaders who have realised that we need to do something, especially if the Senate is going to be worthwhile. Queensland actually did away with its upper house altogether because it was just either obstructionist or rubber stamp. They had all these politicians they were paying big salaries for, and they weren't really doing anything because they were either just agreeing with the government or opposing everything. It wasn't really a house of review. So federally, we took a different view. We just decided to elect it in a different way, using a proportional system. So again, going quickly here, because I know you know this stuff, the proportional representation system compromises fantastically for the weaknesses of preferential voting. It is really fair to minor parties and independents, because if you win 30% of the votes, you're going to win 30% of the seats. If you win 30% of the votes in any lower house electorate, you're not going to win anything. So it's fairer to minor parties, and we do see this in the Senate. It's a much more diverse house. It's got the largest crossbench now, I think, in history. There are 12 Greens there, 12 Greens, and a smattering of other parties making up the largest crossbench. Almost a third of the Senate is non-major parties. It gives voice to many different types of minors. It mirrors the population more. There are more women there than in the House. There are several, or at least one significantly disabled senator in there. There are Indigenous senators, senators from different ethnic backgrounds and so on. It's a really like a snapshot of Australia, much more so than the House. Arguably, the House is very pale, male and stale, although it is getting better. Okay, so the consequences there are because of electoral systems. The downside with proportional voting is it is horrendously complicated to vote and even more complicated to count. We often know the result of the House election on the night that the election day happens. We have to wait a fortnight or more for the Senate results. They're just very, very complicated. Because it's complex, you get a very high number of informal votes. We end up with a balance of power. It's really good to have that diverse number of representatives in the Senate. And it's very rare now that the Senate is controlled either by the government or by the opposition. It's controlled by a group called the crossbench, which is diverse itself. So you have to kind of manufacture a majority there every time you want to pass a bill. Now, this can put some senators on the crossbench into positions of tremendous power. David Pocock, the senator from ACT, independent. He's a teal senator, basically. He is the kingmaker. He's an ACT senator. Think about that. The ACT has what, 300,000 people? And this is a senator representing what, half of them. It's really not democratic. Really, he can say yes or no to bills that the government has a mandate for. So that's a consequence there. And in an accountability sense, you don't really know who to hold to account because there are 12 senators. Who do you blame if they're legislating in ways that you don't like? And you have to know how to use the big complicated ballot paper as well to vote for them or against them. It's difficult. So it's a bit of a problem like that. So this is where we get the Australian electoral compromise. We're now choosing to use two different electoral systems to compensate for the strengths of one compensates for the weaknesses of the other. It is really a good system, but not perfect. Okay, so this is a Senate ballot paper. It's not a real one. It's a model of one. Okay, and on the you know that there's an above the line and a below the line voting. On the right hand side, I've just tried to show with a bit of a timeline starting at the bottom. You just have to imagine that the big black above the line, below the line option is not there. So in 1949 to 1984, there was no above the line. To vote, you had to vote formally, you had to fill in every single box, which in New South Wales could be 70 plus, number them all, think about your vote, not miss any out, not duplicate any, otherwise your vote wouldn't count. You were voting for candidates, not parties, but that was a bit of a nightmare. Many electors just got their metre-long ballot paper and probably just folded up and put it in the box without voting on it because it just was too overwhelming. By 1984, they'd reformed that system by introducing the above the line voting, where you could vote one above the line for a political party or number all the boxes below the line if you wanted to vote for a candidate. If you wanted to kick out a particular senator, you had to vote below the line, because if you're voting above the line, you're not voting for people, you're voting for parties. So the parties actually pick who the senators are going to be. It's not really democratic, but it did make it easier for electors to vote. In 2016, the Turnbull government was the last federal government to reform the federal voting system by slightly making it more difficult to vote above the line. Now you have to number 6 candidates and a lot easier to vote below the line. You've got to vote a minimum of 12. You can vote as many as you like, but minimum 6 above and 12 below. The idea here is to put power back in the hands of voters. We would prefer voters to vote below the line because they're voting for actual senators, not political parties. And by numbering above the line, they are actually preferencing the parties themselves, because prior to that, the parties would preference each other, and it was getting a bit hectic. It wasn't particularly good. There's preference harvesting. You might have read in the book about Glenn Drury, a guy called the preference whisperer, who was able to figure out how to game the system so that minor parties could preference each other in complicated ways, so that somebody with like 0.1% of the vote would win a seat, which is ridiculous. Can't do that now. This table I'm not going to go into in any depth. It really just summarizes all the different aspects of it, of things. You guys have got a copy of this, so we'll move right on. Okay. We can't ignore the Electoral Commission. I'm going to use my last minute just to sing the praises of this. Look at the big gold star there, okay? This system, this thing deserves a gold star. The Australian Electoral Commission is part of the package, right? We've got an electoral compromise, we've got compulsory voting, and we've got an independent administration of elections. You can't really get, this is a rolled gold system, okay? So the Australian Electoral Commission maintains the electoral roll, upholds the integrity of voters, makes sure we don't have any corruption. Look at all the mess in America with Donald Trump claiming that this election was stolen, all of that kind of stuff. Just would not, could not, will not happen in Australia, because the Electoral Commission guarantees how things work, okay? There are no gerrymanders here, etc. And finally, they also suggest reforms to the Parliament, which oftentimes it adopts. This last slide is about evaluating the system. Okay, so again, there's that slide about what an ideal electoral system should do, and some information around the bouts there that fills in some of the things that we've learned through this presentation. The Electoral Act, the Constitution, compulsory voting, the Australian Electoral Compromise down the bottom there, big gold star, okay, and the Electoral Compromise itself. So look, thank you for your attention. Apologies, I think I've gone over a minute or two. Okay, I'm getting the wind up from my colleagues here, and I won't take you any more of your time. So thank you very much, and I'll just introduce you to the next speaker now. Ken, can I speak to you now? Thank you.
Thank you, Stephen. I'm sure we could all listen to him, and I'm sure he could go on all night if he wanted to. All right. So I'm here to talk to you today about a contemporary issue involving the judicial process or justice. We're looking at mandatory sentencing. Mandatory sentencing in our state has been around for quite a long time, as we'll see, but it remains a contemporary issue because of the consequences that have followed because of that. And today I'm going to particularly focus on how mandatory sentencing has impacted our Aboriginal rates of incarceration and also youth detention, both of which have been prevalent in the media lately. Let's start with some sentencing basics. So Parliament is the body that creates offences in our system. A lot of the criminal offences that we're familiar with started off in the common law, but through a process of codification have become embedded in statutes. Most important statute in our state for criminal law is the Criminal Code Compilation Act, or the Criminal Code, but there's many other statutes that also have criminal offences in them. For example, the Road Traffic Act has all of the roads related offences like speeding and driving under the influence, etc. These acts create the maximum penalty for each of the offences. So for example, the offence of assault under the Criminal Code has a maximum penalty of 18 months imprisonment. Parliament also sets directions for judges when they're sentencing through the Sentencing Act, which says the judge must consider both the aggravating factors and the mitigating factors when sentencing someone. So aggravating factors are things that make the offending more culpable. So for example, if we had, let's say, a large scale fraud where someone defrauded $1 million, if it was taken from pension funds or a charity and that had significant flow-on impacts, that would be a significant aggravating factor. Mitigating factors might be things like a plea of guilty, an admission that they did the wrong thing. Perhaps the person was involved in that fraud, but they actually weren't the main player. They just got the money and passed it on to someone else. So their role was relatively minor. Ultimately, the judge's role in sentencing is a matter of judicial discretion. They have to weigh up the aggravating and mitigating factors and then come to the sentence. And they've got various sentencing options open to them. So in our system, imprisonment is the most serious form of sentence. We have various types of sentence under that, such as suspended terms of imprisonment, community-based orders where people can do community work or attend rehabilitation programs. We have good behavior bonds. We have a lot of different things that judges can do. Mandatory sentences are an unusual beast. They're different. They don't specify the maximum penalty. They set the minimum sentence for an offence. Parliament created these types of offences in a reaction to community concerns that offenders were getting off too light in sentencing. Ultimately, the general public doesn't necessarily understand that the judge is weighing up not just all of the bad things and attempting to punish someone, but also the mitigating factors that make a sentence not as severe. And the Sentencing Act says that the judge must take into account the prospects of rehabilitation. So we could make sentencing really easy and say everyone just goes to jail as soon as you commit an offence, but the legislation makes it clear that judges have to try to include in their sentencing thought, how are we going to rehabilitate this person? Our state is the only jurisdiction in Australia to impose mandatory sentences on offenders under the age of 18. And so that sort of touches on that first issue of youth detention that is really, really prevalent in the media at the moment. So let's look at two offences in our state that contain mandatory minimum sentences. Assaulting a public officer. This was introduced by the Commonwealth Code Amendment Act in 2009. The mandatory minimum sentence for a public officer, if you're over the age of 18, is 6 to 12 months imprisonment, depending on the circumstances of the offending. And for young people, between the age of 16 and 18, it's 3 months imprisonment or youth detention. public officers include people like youth detention officers. So if a young person is in the youth detention system and then they are being controlled by the people who work at that office and they get into a fight with that officer, spitting on a public officer would count as an assault, and that would land them 3 extra months in youth detention. We've also had a number of cases in our state involving public school teachers being classed as public officers. So if you are assaulting a public school teacher, you might find yourself in the situation where a mandatory minimum sentence might be imposed upon you. Another penalty that contains a mandatory minimum term in our state is the 3-strike home burglary laws. So these were introduced quite a long time ago in 1996, the mandatory minimum term of 1 year imprisonment for burglaries. In 2013, the then Barnett government campaigned on let's be tough on crime, and they were re-elected and shortly passed the Criminal Law Amendment Home Burglaries and Other Offences Act. And that changed our 3 strikes rules so that we have a mandatory minimum of 2 years imprisonment for adult offenders and kept it as 1 year for juvenile offenders. They also changed how the 3 strikes would be counted. So it used to be you get your third term of, on your third time before the judges, you would be told, I'm sorry, you've had 2 chances. We warned you last time, but you're going to prison for at least a year. Now, the 3 burglaries, so long as they occur on separate days, they still count as separate strikes. So you could end up going straight to jail, even if it's your first time before the judges. There are supporters of mandatory sentencing, so I'll just deal with those who think that's a good idea, some of the arguments that are raised by them. So it promotes consistency in sentencing. You can't get more consistent than a mandatory sentence. It deters individuals for offending or arguably re-offending, particularly with the 3-strike law. So the idea being, if you've had 2 strikes, you know, I'm not going to do it again because I'll definitely end up in jail. It sends a strong denunciation of that type of offence. By Parliament creating a mandatory sentence, it really does send a very significant message that the Parliament, the will of the people is that that kind of offence is not on and we're going to deal with it severely. It does protect the community through incapacitating that offender. They can't go out there and attack or commit other offences if they're in jail. And arguably it reflects the democratic will of the people. If people voted a government in to be tough on crime and they were promising to do that, then it's clearly democratic that we have such laws. In terms of criticisms of mandatory sentencing, there's quite a lot. Chief amongst them is that it unacceptably constrains judicial discretion. So the whole idea of judicial power is that it should be discretionary and they need to take into account the aggravating and mitigating factors in sentencing, but they can't do that in mandatory sentencing. This makes it inconsistent with the principles of separation of power and judicial independence, because we have the legislative branch telling the judicial branch how to sentence someone rather than leaving it open to their discretion. It contradicts the general principle of having imprisonment as the last resort in our criminal justice system, and it reduces the incentive of offenders to plead guilty. And that in turn results in more work in our court system. So you might know under our Sentencing Act, if you plead guilty at the earliest opportunity, you can get an up to 25% discount off your sentence. And the vast majority of criminal offending in WA is dealt with through pleas of guilty. If every single person had to go to a jury trial, then the whole system would grind to a halt. If you're charged with a mandatory minimum sentence, you're not going to get a discount. So there's absolutely no benefit in pleading guilty. So it encourages accused to go to trial. The other thing that it does is it displaces the discretion that would normally lie with the judiciary onto police and prosecutors. So police and prosecutors might be negotiating with accused and their defense lawyers. Well, if we change what we've charged you from an offense that has a mandatory sentence to a different offense, will you plead guilty? And all of that decision making is much harder for the public to get access to. So it's not out there in the open in the way that a court system is. There's a lot of criticism of mandatory sentencing going towards one of the key arguments for it, which is that it would deter offenders. The evidence is that it doesn't actually deter offending, and many argue that it might actually increase the likelihood of offending, because we're taking people and putting them into jail where they're exposed to more offenders and more bad behavior. It's also making it much harder for them to become part of society in a productive way when they get out there. If you've got a jail sentence on your record, it's going to be very hard or harder for you to get a job and participate in a productive way. Mandatory sentences have had a disproportionate impact on Aboriginal and Torres Strait Islander people. So these mandatory sentences are often attached to, and the two that I've highlighted in today's presentation are attached to offences where Aboriginal and Torres Strait Islander people find themselves disproportionately charged. They're attached to so-called crimes of poverty. So particularly the 3 strikes aggravated, 3 strike home burglary law. Those are the types of offences committed by people who don't have other options. And Aboriginal and Torres Strait Islander people, because of generational trauma, have higher rates of poverty and are associated with these kinds of crimes that we're adding mandatory sentences to. So some statistics to bring that point home. In 2002, 81% of young people sentenced under our 3 strikes law were Aboriginal, which is absolutely extraordinary considering that Aboriginal people only make up slightly over 3% of our population. And if we look at the rates of incarceration in our state, nearly 40% of Aboriginals in WA custody as of 2020, which is the most recent statistics that we've got from our corrective services, were Aboriginal. And it's even higher in our youth detention centre. Almost 70% of detainees at our youth detention centre are Aboriginal. Now, mandatory sentences aren't the only factor, obviously, in why these rates are so high, but they're a contributing issue. Let's look at how mandatory sentencing really takes away that lack of discretion from judges. Sentencing is a complex task and not all burglaries are the same. So there was a case highlighted by the Australian Human Rights Commission in their social justice report. It was about a 12-year-old Aboriginal boy from regional WA who had a history of welfare intervention, educational problems, and substance abuse in his family and himself. So extremely disadvantaged child. He found himself sentenced to a 12-month term of youth detention for his 3rd strike after he entered a house and took a wallet containing just $4. So that 3rd strike, obviously not a serious offence by any means, but if we can also take into account the 2 previous strikes, one was for entering a laundry room in a hotel where nothing was actually removed in the end, and the 2nd strike was for entering a school canteen and taking a can of soft drink. So we can see, if we look at the aggravating and mitigating factors, there's not a lot of aggravating factors in this sentencing. There's a huge amount in terms of mitigating factors or factors that should be taken into account in the prospects of rehabilitation for this child. And just slapping a one-size-fits-all mandatory sentence on this situation highlights that this is taking away the discretions that judges usually have to tailor the offence to the offending, tailor the sentence to the offending. A more recent case that I want to use as a study for you is Dee and Edgar. This was a 2019 case in our WA Supreme Court. So the facts of this case, first of all, Dee was a 13-year-old Aboriginal boy from Bunbury, and he was sentenced to a mandated 12 months imprisonment for a home burglary because he had reached his 3rd strikes. At the time of the offending, which wasn't just one home burglary, there was related offending as well, such as stealing. He was between the ages of 11 and 12. He had a severely disadvantaged upbringing. So his father had been in jail most of his life. His mother and father were both involved in substance abuse. There was a report suggesting that he had fetal alcohol syndrome, but it hadn't been formally diagnosed yet. The offending occurred with D and several other boys, all of whom were older than him, and they were sort of the leaders in the offending. D wasn't the instigator. It wasn't his idea to commit these offenses. It was the older children. The older children were the ones breaking down doors and windows. He didn't do any of the damage. When he was caught by police shortly after one of the burglaries, he made full admissions in his police interviews to what happened and was very cooperative. So just in the facts of this case, we can see how sentencing the different people involved, you can't just treat them all the same. D is not in the same level of culpability as the older children. His role was much more minor. He is younger and he's being misled. So it doesn't seem fair, hopefully intuitively, that he be treated in the same way as the other boys. Now, we don't know what happened to the other boys. That's not the focus of this Supreme Court appeal. What happened at the Children's Court was quite an interesting case study into how legislation and the common law intertwine. So at the Children's Court, the Aboriginal Legal Service argued that the judge should use this section of the Young Offenders Act, section 189. It allows the court to sort of ignore previous convictions when it comes to sentencing. And it's got 2 ways it can do that. It can either do it automatically. If a child has been convicted of an offense and it's more than 2 years old, that automatically wipes it from the sentencing consideration. But there's also a discretionary power for the judge to say, well, in special circumstances, I'm going to ignore the prior convictions. So they said to the magistrate at the Children's Court, we think that this child's severely disadvantaged upbringing amounts to special circumstances, and we would like the judge to use the power under 189 to ignore the prior convictions so that he's not dealt with as a 3rd strike. The Children's Court magistrate ruled that she couldn't do that because that would be counter to the mandatory sentencing provisions in the criminal code. She said, if I do that, I'm basically undoing what Parliament intended by introducing the 3-strike law. What happened was the Aboriginal Legal Service brought an appeal to the Supreme Court, and the Supreme Court judge allowed the appeal. The justice found that mandatory sentencing provisions did not override the powers of 189 of the Youth Offenders Act. These situations, according to the Supreme Court justice, did amount to special circumstance. And so those prior convictions that were the first 2 strikes were essentially put to one side. He was resentenced for the offending and no further penalty applied. Of course, you probably know that the appeals process and the judicial process as a whole is very, very slow. And D had already served 11 months of his youth detention sentence in any case. So what are the implications of this Supreme Court case? Well, it means that courts, if they're sentencing a young offender, can use a discretion under section 189 of the Youth Offenders Act to counter the mandatory lack of discretion from 3 strikes rules. It opens the door to other appeals on this ground, and we've seen one very recently in September this year. DJ and the DPP tried exactly the same argument, but the Supreme Court in that case found that the circumstances of the young offender didn't amount to special circumstances under the Young Offenders Act. But all of these appeals create additional expenditure on the very limited funding that the Aboriginal Legal Service has for itself. But given that their clients are in a very difficult position, they of course want to try it for the benefit of their clients. But every dollar they spend on these kinds of appeals is money that they can't spend representing other people, and it creates a real issue as to, oh, we wouldn't need these kinds of appeals if judges were able to give sentences that were tailored to the offending, rather than being forced to input a mandatory sentence and sort of try to get around it with the Young Offenders Act. So potentially in the future, we might see additional legislation in this area to see what happens with it. So I hope you can see how you can use this case study when you're looking at the criminal justice system, when you're looking at the rule of law and separation of powers. I see some very interesting and poignant comments from people on the chat. And I will now hand back to our PLEAWA president, Lisa, to lead us through a Kahoot. Oh.
Thank you, Ken. I'm sure that all of you have just gained some great insightful knowledge into this particular contemporary issue, and whether or not you have studied this or something else, or you've yet to study this might be an area that you might wish to go into to actually revising further. So thank you, Ken, for your great knowledge and wisdom in this area. Guys, if you just want to now get yourself ready for our Kahoot, just give us a couple of seconds while our great tech manager, Daniel here, gets us online. Getting there, guys. Okay. Okay, guys. Okay, thanks, Charlotte. Great to see you jumping on. Remember, guys, to keep your names, credible, appropriate. Otherwise, we'll be bumping you out. Okay, I think we're okay. I think we're ready to go. Thanks, Daniel.
Can read them out.
Okay. The Westminster system encourages what form of government? Ooh, at least 24 of you knew. That's good. Well done. Excellent work, James D and Chantel. Raccoon, Shiv and Albie. Yeah, they're inching up there. Okay, next question. Which of these are not found in Australian elections? Oh, okay. 30 of you, that's great. Let's maybe work on that, 4 of you. Okay, Chantal, nice one. Okay, next question. Chapter 1 of the Constitution refers to which arm of government? Key question from tonight. Okay, wonderful, except for 8 of you. I'm quite, yeah, a bit shocked by that one, but hopefully we can work on that one. Okay, James D, well done. And Hannah Shenton, you for the highest answer streak. Fantastic work. Okay, next question. How does the Senate allow representative government to occur? I need you to know that whoever wins this will get a signed copy of a good answer guide by the well-renowned Mr. Stephen King. I think that's well worth winning. Oh, and all the presenters from tonight's seminar. Okay, well done, 27 of you. Keep working on those, the other 5. Oops, Clark Graham, you've come right up there with that one. Fantastic.
Keen for Stephen's signature.
Yeah, keen, exactly. For all the other presenters. Which sections of the Constitution imply the right to vote? That's a good one. Even some of our presenters are participating in this. Okay, 17 of you knew that. Fantastic. That's a great one to know for the Roach case for section 7 and 24 for the implied right to vote. Please make sure that you know that one. Chris, well done. Very good. Shiv, you're still in there. Jesse, Clark Graham, keep going. Okay, single member electorates are a feature of. Stephen mentioned this tonight. Okay, beautiful, 17 of you. Fantastic. So the House of Representative elections. All right, Clark Graham up there again. That was a tough round. 3 players lost the answer streak of 5. Let's keep going. Okay, when was compulsory voting first introduced in Australia? Oh, fabulous, guys. You did listen to Stephen King. Well done. Maybe, no, 10 of you didn't. But we'll get there. Okay, next. Oops, it's a bit of a spelling error, but what is an absolute majority? Yeah, you can do it. Oh, nice one. Tiana is back with an answer streak of 3. Clark Graham, you are racing away to get that signed copy. A political legal system with a national government, at least 2 or more regional governments, is known as. Great essential understanding for Unit 1. Okay, well done, Clark Graham. James D. Which is not a concurrent power in Australia? Okay, let's see. 10 of you. This is a bit worrying, guys. Let's get back to that Constitution. We all should have a little copy of the Constitution with us at all times. Yeah. Okay. Oh, James D, fantastic. Layla B, you're making a comeback with 3 in a row. Fantastic. Which of the following are residual powers? Okay, 13. Again, let's keep working on those exclusive concurrent residual powers, especially because if you're taking on year 12, you'll definitely need to know this one. Okay. Oh, Rosie, well done. Up 5 places. Jessie's the highest climber. Fabulous. Okay, which is not a convention of the Australian political system. Mm. Mhm. Okay, well done, guys, particularly because that's something that Alex spoke about at the beginning about those conventions. Need to know, particularly going into year 12. Rosie, fabulous. Which section outlines a formal process to change the Constitution? Something we did back in year 7.
Mm-hmm.
We can remember. I'm hoping 100% winning streak with this one. Oh,
No.
oh.
Oh, that's bad.
Oh.
Our teachers are feeling a bit dismayed right now. Okay, James D is coming back. Panda is back with an answer streak of 3. Well done, Panda. Okay, how many referendums have been successful? Might not have looked at this so much this year, but definitely for next year, you'll need to know this one. Oh, okay, well done. You have redeemed yourselves. Well, 9 of you have it. Maddie, well done. Excellent. Raccoon, you're the highest climber. And you're considering your name too. Okay, the right of every citizen to access the courts to present their case is a part of. I like that. Oh, well done. I'm very impressed. 4 of you. Let's work on that. Okay. Maddie, well done. James D, you're still in there. Rosie, Chantel, and Chris, keep going. The reasons for a decision are known as. Yeah. We're all walking away if this is shutting down the Kahoot if they don't get this one.
Dr. He should be invited to this team.
Oh, 5. Well done, 26. Come on, 5 of you. Maddie. Go. The 4 main types of law are. Ooh, not bad, guys. And some nice moves there. 4 players just dropped the answer streak, those. Come on. Which of the following are principles of the rule of law? No one click yellow or brown, whatever that colour is.
There's songs about that.
Oh, someone had to be cheeky and press it, didn't they? Hey. Okay, come on, guys. Tadisa is making a comeback. And what is the highest court in Western Australia? Oh, very quick on the buzzer with that one, guys. 18 got it. 12. Ooh, okay. Be very careful. This is just in the court hierarchy for Western Australia. Okay, opportunity. Ooh, for Clark Graham, Jesse. So come on, guys. 5 to go. The legislative arm of the US government is called. Quick on the buzzer. Okay, well done, Maddie, Chris, James D, Jesse, Chantal, and Tiana's back with an answer streak of 3. Deliberate manipulation of electoral boundaries is known as Jerry Mooching. Okay, well, oh, excellent. 3 of you, let's work on that. However, well done, 27 of you. Where are we? Maddie's still racing up there at the top there, Chris. Chantel's making a comeback though. True or false? Presidential and congressional elections are organised by the federal government. Ooh. Chris. Yeah, that's right. We did have a US PLEAWA presentation earlier in the year, guys. Okay, is it basically, is it compulsory to vote in the US? I think that everyone should know that. Oh, do not laugh at me, everyone. And I did not put the wrong answer there. Okay, Chris has taken it away. All right, here we go. True or false again? US citizens directly vote for the president.
Ooh.
50-50.
Yeah.
Oh.
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 Electoral college.
Yes, that's right. The electoral college, guys. Okay, Chris, Jesse. Jesse has a streak with 14 correct answers in a row. Let's go, Jesse. Last one. The electoral college contains how many votes? Just taking it to the end. Countdown. 13 of you got it correct. 5, 3, 8. Let's see who wins. The winner is podium goes to 3rd place. Chris, well done, Chris. Bit of a dance there for Chris. And then James D came up 2nd. Fantastic, James D. But number 1, let's take it to the top, is Jesse. Well done. Big round of applause. And runners up, Chantal and Rosie. Fantastic, guys. Last and final, thanks very much, guys, for joining. But I wanted to also make you aware that please purchase the Democracy and Justice Study Guide from the PLEAWA website. That will also help you with some great case studies.
Jesse needs to email.
Oh, and Jesse, could you please email the secretary in regards to your question?
Signed copy.
To the signed copy. I meant Jesse. Thanks, everyone. Bye.